my first contribution in this debate, addressing my remarks to part one. May I first just also join with my colleagues in remembering the 5th anniversary of Pike River and how the events of that day shocked the nation, stopped us in our tracks, and have to some extent reshaped our nation. As with all major events, you always remember where you were when they happened, and I happened to be standing on a grass verge in Mana, waving a sign in support of my colleague Chris Farfoy. Of course, none of that mattered. The most important thing was what was happening on the West Coast. But at least one of the good things that emerged post that was getting my colleague Chris Farfoy into Parliament. Following on from my colleague William's CO around good process, one of the things the thing that really is the most disturbing thing about this piece of legislation, which on the face of it looks relatively minor, is that it's about good process, or it's actually about bad process and fixing bad process. And there are some significant questions that the Minister can and needs to answer, and I've got a couple of them to pose in this contribution, because, Mr Chair, that the public should be aware that this government has made a habit of passing shoddy, rushed legislation under urgency through with no select committee scrutiny, or another trend has been to truncate the select committee process. There are too many pieces of legislation that is going through this kind of process, and as a result, you end up with unscrutinised law, and you end up coming back and having to fix it, which is what is happening here. And this government claims that it's transparent, but nothing really could be further from the truth when you look at the sheer number of legislation that passes through so quickly that it's riddled with errors and mistakes. My comments specifically relate to Part 1, Clause 6, which is the amended part of the right of appeal to the High Court on question of law, which is a replacement section, which according to the departmental disclosure statement, is a minor and technical amendment to fix an error in the drafting of the Principal Act relating to the procedural requirements for the filing of appeals on question of law within the High Court. Now, my question to the Minister is, what are, if there are, what are the legal implications of this? And given that we haven't been able to, we don't have a regulatory impact statement, we don't have the advice from Parliamentary Council, all we have is a departmental disclosure statement. This may look as if it's not, and it's been described as minor and technical, but what are its implications in law? And I would ask the Minister during his contributions during Part 1 of the bill to tell the House whether or not there has been a legal opinion provided on this particular Clause 6, which makes the change that notice of appeal must be filed with the High Court and served on the Auckland Council no later than 20 working days after the Council notifies matter. Now, given the the impact and the import of the principles behind this piece of legislation, and Auckland is our biggest city, the process that are being set out in law under the unitary plan are significant, have significant impacts. By making that change, surely there must be some kind of legal implications, and I think the House needs to know what they are. And if they haven't been sought, then the House needs to know why not. I also want to make reference to clause 8, Mr Chair.
Sorry. Gareth Hughes.